Here's something that could change everything for you and your family. Most people think they're prepared for medical emergencies because they have insurance. But there's a critical gap in their planning that could leave their loved ones making impossible decisions without guidance. And it's not what you think. I'm talking about the difference between a living will and a healthcare power of attorney. These two documents sound similar, but they serve completely different purposes. And not having the right one, or worse, having neither, could mean your wishes are ignored when it matters most. Let me tell you why this is so important. Every single day, families across the country face heartbreaking situations where they don't know what their loved one would have wanted. They're forced to make life and death decisions based on guesses. This doesn't have to be your family's story. So what exactly is a living will? Think of it as your voice when you can't speak for yourself. A living will is a legal document that spells out exactly what medical treatments you do and do not want if you become unable to communicate. It covers situations like being on life support, receiving artificial nutrition, or undergoing resuscitation efforts. The power of a living will lies in its specificity. You can state clearly whether you want to be kept on a ventilator if there's no hope of recovery. You can decide in advance whether you want feeding tubes if you're in a permanent vegetative state. You can even specify your preferences about pain management and organ donation. But here's where it gets interesting. A living will only kicks in under very specific circumstances. It typically only applies when you're terminally ill, permanently unconscious, or in the final stages of a fatal condition. Outside of these situations, your living will sits on the shelf. Now let's talk about healthcare power of attorney. This is a completely different animal. Also called a healthcare proxy or medical power of attorney, this document names a specific person to make medical decisions on your behalf when you can't make them yourself. This person becomes your advocate, your voice, your decision maker. The person you choose as your healthcare agent has broad authority. They can talk to your doctors, review your medical records, and make treatment decisions based on what they know about your values and wishes. They step into your shoes for all healthcare matters, not just end-of-life situations. Here's the critical difference. While a living will is limited to specific end-of-life scenarios, a healthcare power of attorney covers any situation where you're incapacitated. Maybe you're unconscious after a car accident. Perhaps you are heavily sedated after surgery. You could be dealing with severe dementia. In all these cases, your healthcare agent can act on your behalf. Think about it this way. A living will is like leaving detailed instructions for a specific situation. A healthcare power of attorney is like having a trusted person who can adapt to whatever comes up. Both are valuable, but they serve different purposes. So which one do you need? Here's the truth that surprises most people. You need both. They work together to provide complete protection. Your living will gives clear guidance for end-of-life situations. Your healthcare power of attorney ensures someone can make decisions in all other medical scenarios. Let me explain why having both matters so much. Imagine you're in a serious accident and you're unconscious but not dying. Your living will doesn't apply because you're not terminally ill. But your healthcare agent can immediately start making decisions about your treatment. They can authorize surgeries, choose specialists, and decide on rehabilitation options. Now imagine a different scenario. You've been diagnosed with a terminal illness and you're in the final stages. Your living will clearly states you don't want extraordinary measures to prolong your life. Your healthcare agent can use that document to ensure your wishes are followed, even if other family members disagree. The combination of these documents creates a safety net. Your living will provides the what, the specific instructions for end-of-life care. Your healthcare power of attorney provides the who, the trusted person who can interpret your wishes and make decisions in real time. Choosing the right healthcare agent is crucial. This person needs to understand your values deeply. They need to be able to make tough decisions under pressure. They need to be willing to advocate for you even when it's difficult. And they need to be someone you trust completely. Many people choose their spouse or adult children as healthcare agents. Others select a close friend or sibling. The key is picking someone who knows you well, shares your values, and has the emotional strength to make hard choices. You should also name a backup agent in case your first choice is unavailable. When you create your living will, be as specific as possible. Don't just say you don't want extraordinary measures. Define what that means to you. Do you want CPR attempted? What about dialysis? Would you want antibiotics for infections? The more detailed you are, the easier it is for your healthcare team and family to honor your wishes. Some people worry that creating these documents is morbid or pessimistic. Actually, it's one of the most loving things you can do for your family. You're removing the burden of guessing what you would want. You're preventing family conflicts that often arise when there is no clear guidance. You're giving everyone peace of mind. Timing matters too. Don't wait until you're facing a health crisis to create these documents. Do it now, while you're healthy and can think clearly. These documents can be updated anytime your wishes change. Many people review and revise them every few years or after major life events. The legal requirements for these documents vary by state. Some states have specific forms that must be used. Others are more flexible. Most require witnesses or notarization. It's worth consulting with an attorney to ensure your documents are valid and will be honored when needed. Cost shouldn't be a barrier. Many states provide free living will forms online. Some hospitals and senior centers offer assistance with these documents. Legal aid organizations often help with healthcare directives. If you want more complex planning, an estate planning attorney can help, typically for a few $100s. Once you've created these documents, don't just file them away. Give copies to your healthcare agent, your doctor, and close family members. Keep a copy in an easily accessible place at home. Some people carry a card in their wallet indicating they have these documents and where to find them. Make sure your healthcare agent knows your wishes in detail. Have honest conversations about your values, your fears, and what quality of life means to you. The document gives them legal authority, but your conversations give them the knowledge to use that authority wisely. Here's something many people don't realize. Without these documents, the default decision maker is usually determined by state law. This might be your spouse, your adult children, or your parents. But what if they disagree with each other? What if the person state law designates isn't the person you would choose? These documents let you control who speaks for you. Some situations require special consideration. If you have strong religious beliefs that affect medical decisions, make sure those are clearly stated. If you're in a non-traditional relationship, a healthcare power of attorney ensures your partner can make decisions, since they might not be recognized as next of kin under state law. For parents of adult children with disabilities, these documents are especially important. Once your child turns 18, you no longer automatically have the right to make their medical decisions. A healthcare power of attorney ensures you can continue to advocate for them. Young adults often think they don't need these documents. But accidents and sudden illnesses don't discriminate by age. If you're over 18, you should have at least a basic healthcare power of attorney. It takes less than an hour to complete and could prevent enormous complications. Technology has made managing these documents easier. Many healthcare systems now have electronic health records where you can upload your advance directives. This ensures they're available to any doctor treating you within that system. Some states have registries where you can file your documents for easy access in emergencies. Remember, these documents can be changed or revoked anytime you want. If your wishes change, update your living will. If you want to choose a different healthcare agent, you can do that too. The goal is to have documents that accurately reflect your current wishes. One final thought. Having these documents is an act of love and responsibility. You're taking control of your future healthcare. You're protecting your family from impossible decisions. You're ensuring your values guide your care even when you can't speak for yourself. Don't put this off. Start the conversation today. Download the forms for your state. Talk to your family about your wishes. Choose your healthcare agent. Create your living will. These simple steps today could make all the difference tomorrow. Your future self and your family will thank you for having the courage to plan ahead.